Hello guys, welcome to my channel. Interpreting Insurance Contract Special Consideration Part 1. Covenant is a temporary and limited agreement. It may be self-contained or it may incorporate by reference the terms and conditions of the future policy. When the covenant incorporates the policy in this manner, it does not have to recite a term and condition, but merely to refer to a particular standard policy. If the proposal is for a standard policy and the covenant refers to it, the insured is taken to have accepted the terms of that policy. The reference to the policy and its terms and conditions may be expressed in the proposal or the covenant, or even in the letter of acceptance including the covenant. The incorporation of the terms and conditions of the policy may also arise from a combination of references into or more documents passing between the parties. Documents like the proposal, covenant, and the policy are commercial documents, and to interpret them, commercial habits and practice cannot altogether be ignored. 4.3. During the time the covenant operates, the relation of the parties are governed by its terms and conditions, if any, but more usually by the terms and conditions of the policy bargained for and to be sued. When this happens, the terms of the policy are incipient, but after the period of temporary cover, the relations are governed only by the terms and conditions of the policy. Unless insurance is declined in the meantime, delay issuing the policy makes no difference. The relation even then are governed by the future policy if the cover not give sufficient indication that it will be so. 4.4. In other respects, there is no difference between a contract of the insurance and any other contract, except that in a contract of insurance there is a requirement of bona fides, good faith on the part of the assured, and the contract is likely to be construed contract performance that is against the company in case of ambiguity or doubt. A contract is formed when there is an unqualified acceptance of the proposal. Acceptance may be expressed in writing, or it might even be improved if the insurer accepts the premium and retain it. In the case of the assured, a positive act on his part by which he recognizes or seeks to enforce the policy amounts to an affirmation of it. 4.5. Even if the letter of acceptance went beyond the covenants in the matter of duration, the terms and conditions of the proposed policy would govern the case because when a contract of insuring property is complete, it is immaterial whether the policy is actually delivered after the loss, and for the same reason, the rights of the parties are governed by the policy to be. Between acceptance and delivery of this policy, even if no terms are specified, the terms contained in a policy customarily issued in such cases would apply. There is ample authority for the proposition. 4.6. When a contract of insuring property is complete, it is immaterial whether the policy is delivered or not, for the rights of the parties are regulated by the policy which ought to be delivered. 5. The principle of uberi fide, good faith, govern insurance contract. 5.1. Contract of insurance are governed by the principle of utmost good faith. The duty of mutual fair dealing requires all parties to a contract to be fair and open with each other to create and maintain trust between them. In a contract of insurance, the insured can be expected to have information of which she or he has knowledge. This justifies a duty of good faith, leading to a positive duty of disclosure. 5.2. The contracts of insurance, including the contracts of life insurance, are contracts with bona fides and every fact of material material fact must be disclosed, otherwise there is good ground for rescission of the contract. The duty to disclose material fact continues right up to the conclusion of the contract and also implies any material alteration in the character of risk which may take place between the proposal and its acceptance. If there is any misstatement or suppression of material facts, the policy can be called into question. For determination of the question whether there has been suppression of any material facts, it may be necessary to also examine whether the expression relates to a fact which is in the exclusive knowledge of the person intending to take the policy, and it could not be ascertained by reasonable inquiry by a prudent person. 5.3. An insurance contract in a species of commercial transaction and must be construed like any other contract to its own terms and by itself. In a contract of insurance, there is a requirement of prima facie, good faith on the part of the insured, except that in other respects there is no difference between a contract of insurance and any other contract. 5.4. A contract of insurance is one of utmost good faith. A proposer who seeks to obtain a policy of life insurance is duty-bound to disclose all material facts bearing upon the issue as to whether the insurer will consider it appropriate to assume the risk which is proposed. It is with this principle in view that the proposal form requires a specific disclosure of pre-existing ailment so as to enable the insurer to arrive at a considered decision based on the actuarial risk. 5.5. A mediclaim policy is a non-life insurance policy meant to assure the policyholder in respect of certain expenses pertaining to injury, accidents, or hospitalization. Nonetheless, it is a contract of insurance falling in the category of contract über remediefide, meaning a contract of utmost good faith on the part of the assured. Thus, it needs little emphasis when an information on a specific aspect is asked for in the proposal from an insured is under a solemn obligation to make a true and full disclosure of the information on the subject which is within his knowledge. 5.6. It is standard practice for the insurer to set out in the application a series of specific questions regarding the applicant's health history and other matters relevant to insurability. The object of the proposal form is to gather information about a potential client, allowing the insurer to get all information which is material to the insurer to know in order to assess the risk and fix the premium for each potential client. Proposal forms are a significant part of the disclosure procedure and warrant accuracy of statement. Utmost care must be exercised in filling the proposal form. In a proposal form, the applicant declares that she or he warrants through. The contractual duty so imposes is such that any suppression, untruth, or inaccuracy in the statement in the proposal form will be considered as a breach of the duty of good faith and will render the policy voidable by the insurer. The system of adequate disclosure helps buyers and sellers of insurance policies to omit a common point and narrow down the gap of information asymmetries. This allows the parties to serve their interests better and understand the true extent of the contractual agreement. 5.7. The finding of material misrepresentation or concealment in insurance has a significant effect upon both the insurer and the insurer. In the event of a dispute, the fact it will influence the decision of a prudent insurer in the claim as to whether or not to accept a risk is a material fact. Each representation or statement may be material to the risk. The insurance company may still offer insurance protection on altered terms. In a similar case, however, the court has held that since the undisclosed disease had nothing to do with the cause of death, the alleged concealment was not unnatural, which would disentitle the deceased from getting his life insured, and hence the court found the repudiation of the claim unjustified. In part 2 of this blog, we will delve into other principles which form the basis for interpretation of insurance contracts, including presumption as a materiality of information sought, effect of misrepresentation, and the applicability of the rule of contract performance to insurance contract. Thank you for watching, guys. Don't forget to share this video. Goodbye.